we have about 15 minutes, and I would like to hear not only questions by all of you, but also brief opinions. And after that, we will come back to the panelists for final 2 minutes each. I want also Kasim to tell us about the opportunity of the regional.
My position is that I don't have an idealistic expectation of the ICC. It's not perfect. The world in which we live is very flawed and very imperfect. But my slight reservation with Dr. Kasim is that post-World War II, there were very limited options, I think, of what the so-called Allied countries could have done with the Nazi leadership. It's either they could have executed all of them summarily, that's one option, or they could have tried them, which was what they did. Now, I'll be the first to say that in all ramifications, we can say that the trial, the Nuremberg trial, the Tokyo trials, were not, they were not perfect, but they did give us a framework that could inform post-conflict justice several decades on. Again, let me be clear, it wasn't a perfect outing, but put side by side with the option of summarily executing those people, I think Nuremberg was a better option with hindsight. And that's why I say I don't have an idealistic expectation of international justice. Second thing is that it applies to universal jurisdiction as well, I think. I listened very carefully to Professor Stephen, and again, while I raise my hands in support of universal jurisdiction, it is going to be tempered by the reality of realpolitik, and we've seen what the likes of John Bolton have had to say, and even the explicit threat that he made against the ICC quite recently about the US cutting off funding and the rest of it like that. So that's how I wish to rest my contribution. It is not perfect, and we should not look at it as a perfect organization.
Yes, who wants to go next?
In the law, like animal rights activists, there are who would, for instance, to prohibit cruelty towards domestic animals like pets. So if you prohibit slaughter of cows, shouldn't come also provisions about what to do with aged cows, because there are a lot of stray cattle, and if you really care, like if let's take this position hearing about cattle, shouldn't be some realistic assessment of the role of the farmer who has old cows and who puts his old cows on the street? That's also cruelty. So he has a dilemma. He has nothing to do with them, because putting them on the street means giving them a very poor quality of life as a stray animals. So there should be some consistency about it to be. Like if you want to prevent cruelty towards animals. That's one. And second, to Stephen, paradox that states which need the universal jurisdiction most are the states which are most unlikely to apply it. How to deal with this paradox? Which power can stay behind universal jurisdiction to bring it to states like China, for instance? I think it needs it heavily.
Exactly. Excellent question. Okay, I see two hands from students, and let's give them the chance. Yes, please.
Listen, Professor Stephen, what do you call? You brought up John Bolton's view on how the ICC infringes on democracy itself or the sovereignty of the country. Do you have any response to that, if so? And Woodson, if even though you skipped over the US, isn't it important to look at how you could be perceived, in the sense that that could be considered politics too? Not an allegation, just a joke.
Good. And over there, please.
My question is for Amit sir. Recently I went through some of the literatures written by V. Savarkar, and he in his Vigyanation even said that we should protect cow not for the sake of religion, but for the sake of economy. But now we see that India has on one part overly criminalized the killing of cow, and it's now quite a big crime. And on the other hand, India is also becoming one of the biggest beef exporters.
The biggest.
the biggest peak exposure.
Thank you. Jay?
So I wanted to actually ask a question to Ashmi about the exceptionalism point that you made. One of the, in American political science discourse, one of the fears is that talking about exceptionalism oftentimes will move people in the direction of nationalism, jingoism. I think about the debate between Seymour Martin Lipset and Graham Wilson, who was one of my teachers, where Wilson's response was a book that he called, to Seymour Martin Lipset's idea of exceptionalism being a sort of classic U.S. case study. Graham Wilson responded with his book called Only in America, ? Which was basically a rebuttal to say, this notion of exceptionalism is a myth. And we actually had this discussion a bit yesterday when we were talking about cross-border studies and whether, for example, Russia is completely unique, whether it's really, and it can't be compared to other countries. And I guess I would be interested in just your thoughts about that current discussion, given the comments that you made.
Excellent. I think we should stop here. We have plenty of material to digest and to respond. Just to add on the exceptionalism, and I really would like to link this into the debate about complementarity and Article 17. See how interesting is those who are in the statute, like British, they say we have the best legal system, so we don't worry to be part of the wrong statute and to apply the universal jurisdiction, exactly because we trust in our judges and they will be proper and they will do the job, and the prosecutors and the whole system will work well. So we don't worry from ICC exactly because we will do under the complementarity the best job. It's kind of also judicial exceptionalism. But see how different it becomes when it is to the United States, which say we have the best legal system, we don't need the ICC at all. They simply don't read Article 17, which gives the members of the ICC the first goal and to prosecute domestically. So in a sense, the exceptionalism can apply both ways. If you argue to have the best legal system, you should be very happy to be part of the international system as well as domestic system. Okay, let's go now into the, let's start with Kasim again and go the same order.
Briefly extended the jurisdiction of the yet to be established African Court of Justice and Human Rights, which gives jurisdiction to the court on issues concerning international crimes, war crimes, genocide, and crimes against humanity. But then the problem here is when you look at it, there is immunity for head of states, which obviously most of the times will be the persons who will be implicated in that. And then when you look at also the idea behind merging of the two courts, the African Court of Justice and the African Court of Human Rights, together was on the basis of lack of funding. And now you are adding complex issues like international crimes, which require a lot of funding. When we look at the ICTY, the ICC, and ICTR, in the first 13 years of the ICTY, it was estimated that about 1.2 billion were allocated, and then at some point, even per case decided by the ICTY, it costed $18 million. And then you look at the budget, like in 2008, 2009, the budget of the ICTY was about 267 billion. And then you look at the annual budget of ICC is about 160 million. Now, where will the court get the resources to actually function in that way? So the possibility that such things will be addressed by by the African courts is actually very remote. Secondly, concerning the principle of complementarity, well, I appreciate that with respect to some developed world, it may not be very, very difficult issue, although you pointed it out that they should even be willing to accept the international system. But then with respect to the African situation, they accepted it because they knew very well what it means for them, what benefit it will give to them. Because before you can prosecute, you need to have the domestic legislation that will allow for such prosecution because of the problem of principle of legality. Now we look at even those states which are parties to the ICC, I think only about 11 of them have domesticated these international crimes in their law. So, but when you look at also before they can be able to prosecute those crimes, they need to put sufficient things in place, like having an institutional mechanism that will address all the issues there. But then when you look at the situation there, there is really no possibility of that being addressed. The mechanisms are not really very strong enough. There is lack of professional capacity. There is no political will to address all the issues there. So complementarity is actually a very important issue for them. And the contribution by Kulli relating to the limited options available for the International Military Tribunal for Nuremberg and the other one after the Second World War. But then, well, we are not actually dismissing the contributions made by this. We recognize that they have limited options at the time, but the issue is the selectivity, the bias demonstrated in the prosecution of cases. That was where the influence of politics can be actually manifested. Because the concern is, why did you only limit it to Nazi war criminals when in fact you yourselves, you are implicated in it? Why didn't you prosecute? So it's not denying the fact that they have contributed a lot in the field of international criminal law, international military law.
Thank you, Kasim. I think we agree on that, that in fact this not catastrophic. It will be genocides after genocide. Cambodia, Rwanda, all this will continue to happen if there is no international law. Rasmi.
Thanks, Veslin. Thanks for the question, Jay and Veslin. I have, well, my idea on exceptionalism, I completely agree with you. The heart of deconstructing exceptionalism is to argue that it is remarkably unexceptional. And that is the position taken by anyone outside who tries to break through exceptionalism. In the case of Russia, I think that this is most clear in Russia's position in the European Court of Human Rights. Not really in international criminal law, because it's harder to assess. There's no membership, etc. But Russia's position on the Council of Europe, and especially this, what's being called in writing, in academic writing, as the Zorkin effect. The writings of Valery Zorkin, the Russian judge, head of the Constitutional Court, possibly still the head of the Constitutional Court? Yes? Okay. So this is in contrast to what we call Strasbourg effect, that is holding states that are parties to the European Convention on Human Rights to standards given by that convention on the protection of human rights, which are to trump the national standards. But there is there's a equivocation that's been done by other states that are parties to the treaty, which is the so long effect, where they say that so long as you can prove that the domestic standard offers an individual a higher protection of human rights than the regional standard, the domestic standard will prevail. Russia has been a member of the is a member of the European Convention on Human Rights, but has maintained that the European Convention doesn't apply at home, arguing, just like America, that the standard of protection available under its municipal law is higher. And I think this is also an explanation for, I was reading about a case, LM versus Russia, which is a European Court of Human Rights decision in 2015, that directly talks about the example that Steve took, the repatriation of Syrian refugees from Russia, who were being sent back by Russia to Syria in clear violation of the principle of non-refoulement under refugee law. And Russia's reluctance to recognize the principle of non-refoulement, it's got nothing to do with treaty law, it's a principle of customary international law. But these are sovereign behavioral patterns that make a state look monist to other states, that make a state look as if they reject the spheres of influence between international law and municipal law. And I think this is the basis for their claims of exceptionalism. States that say that their constitution is supreme, it's not because they don't believe in international law, but because they perceive of the international as a separate sphere, and that has nothing to do with the municipal. So yeah, that's
Thank you. Although you're right pointing to that about Russia denying the European Convention of Human Rights to have effect, when you say Russia, you probably mean the politicians, because I've collected in my previous research a lot of judgments who actually Russian judges apply very well the European Convention of Human Rights, and they quote that they rule because of previous judgment of the Strasbourg Court. So there is a part of the judges in Russia look at the European Convention very seriously. So it's a bit of a debate about exactly the separation of power, what the politicians say, and what the judges may actually revert. Okay, Steve.
I really have very little to add to what Russia in the international sphere. They're going to behave in the ways that they perceive, that their leaders perceive, protect their national interests, and in doing so, they're going to challenge an underlying precept of international law, which is that it is an act of sovereignty to ratify the United Nations Charter, which recognizes the principle of the sovereign equality of states, and the need to apply rules of international law and peaceful settlement of disputes and all the rest. So the question of complementarity, I think, in the case of international criminal law is a very strong answer, as you pointed out, a very strong answer to the question of the very concept that anyone from our country could be tried by some tribunal of a bunch of bureaucrats is actually responded to by the fact that no, that in fact your adherence to a process that allows for it and the application of the principle of complementarity means that it is an exercise of sovereignty of the state. It is not incompatible. So it's an exaggeration, a stretch, when you have Bolton referring to an assault on the constitutional rights of the American people because in secular terms, we don't recognize any higher authority than the U.S. Constitution. Well, I guess I remain a liberal internationalist. I actually think there is a higher law than the U.S. Constitution, and I would like to see it applied.
Yeah.
Oh, and that said, I would also like to take with me, when I report back to the Security Council and to the Human Rights Council, that this conference of Russian-Indian conference has agreed that those responsible for the acts perpetrated in Syria deserve to be prosecuted under universal jurisdiction. I will take that universal agreement here back to the Security Council and the Human Rights Council.
Very good outcome of the conference, I guess. Very interestingly, that those who criticize various tribunals, they are not happy when the big powers create tribunals, like it happened with Yugoslavia and Rwanda, and they say, why the Security Council has powers to establish a tribunal, and they are not happy with that. But when the small and middle powers create the ICC without the big powers, they're also not happy with that, and they're not happy with universal jurisdiction and with domestic. So I'm questioning, what are you happy with? Amit, your final word.
Trying to be quick, I think this was a very important question, and I think, I realize with the question that if we frame sometimes the question correctly, then that solves the problem half, because we are asking wrong questions. So yeah, but you're right that the question of cruelty is important, and but interestingly, the question of cruelty is something that is never an issue in the debate. In fact, the question of cruelty will lead us to preservation. And so there are cow protection homes which government has created, not enough. So earlier, farmers who would sell their cows unproductive to be slaughtered now can't, because that would be a criminal offense. So now they would let them go. So possibly more cruelty in your sense of the term is, is something that is exacerbated. So possibly the question of cruelty is a more important question. And unfortunately, we have reduced this question to on a totally different tangent. And that's the right question. On the other question, maybe we can have a longer talk on that later. But it's very interesting the way you read Savarkar, because Savarkar is a very important thinker. And I say interesting because by this logic, if it is about economy and India is the greatest beef supporter, where you are right, then actually government is not taking Savarkar seriously. So they should do by your reading. But on the other hand, I would say that if you look at the writings of Savarkar, then the question of economy is more complicated, because the way the old historians have pitched the question of Cow as economy versus religion is actually faulty if you look at the writings of another man called Dayanand Saraswati, who has written a good book called Go Karunanidhi, which Savarkar approvingly cites. And there you would realize that in the Indian discussion especially, the question of economy and religion is not so neat as it is made out by many historians. And there is some work which has started on this line that you can't neatly divide economy and religion, especially the way Indian thinkers, Savarkar, you have mentioned. I would recommend you to read Dayanand Saraswati if you look at.
Thank you. I must say this is one of the most exciting panels I've done in my 5 years in Jindal. There are so many questions and we couldn't really, there are more questions than answers, which makes it beautiful exactly because we go back and we start thinking again and again. And I think we can do easily a conference or a day and a half on this particular topic. So thank you all, the panelists, for the amazing